was far worse than tortured logic about torture. It was a dark constitutional fantasy, a remarkably wrong interpretation of the nation's highest laws, handed over to the Bush administration as if it were law, because for more than 7 years it effectively was law. In our third story in the countdown, the Bush-era post-9/11 John Yoo Justice Department memos. Scott Horton, the international human rights lawyer who pegged this for what it was, a blueprint for dictatorship, will join us presently. What the Justice Department's Office of Legal Counsel did after 9/11 in memos by John Yoo, but not him alone, bluntly described in Mr. Horton's column in Harper Magazine. He, Yoo, concluded that in wartime the president was freed from the constraints of the Bill of Rights with respect to anything he chose to label as a counterterrorism operation inside the United States. Thus, as Karl Rove and Harriet Myers prepare to testify about a different set of Bush administration abuses, who will answer for these legal memos, only some of which have been released? Mr. Horton wrote, "We may not have realized it at the time, but in the period from late 2001 to January 19, 2009, this country was a dictatorship." Joining me now, as promised, a legal expert in international human rights and emerging markets, contributing editor for Harper's Magazine, Scott Horton. Thanks for your time tonight, sir.
Hi, Keith.
Let's start with the retroactive devil's advocate point. Bush did not order at any point the military seizure of part of Cleveland. He did not imprison Marcus Militzis. This was certainly not an active military dictatorship or dictatorship of any kind in anybody's tangible perception. So what do you say to the idea that these were just outer parameters in the event of true internal chaos?
Well, all true. I mean, certainly it wasn't 7 days in May, but it also wasn't a theoretical or academic exercise. These memoranda were crafted with specific programs and projects in mind, and the question is exactly what. I mean, if we go in and we look at some of the most troubling of the memoranda, there's a clear focus on the use of the commander-in-chief powers, the use of the military domestically in the United States. And John Yoo says the Fourth Amendment presents no impediment. Well, the Fourth Amendment, of course, is a limitation on surveillance. It creates a requirement of warrants for listening in to people's telephone conversations, for instance. And in this case, I think it's pretty clear that this was designed to authorize the military agencies to engage in a sweeping program of surveillance in the United States. In fact, one thing really leapt out in this memorandum, and that was the juxtaposition of the Fourth Amendment with the First Amendment. A statement that by the same reasoning, the First Amendment wouldn't contain the limitation. I don't think that was put there gratuitously. You had Russell Tice on your show just a few weeks ago talking about the fact that journalists were specifically targeted in one aspect of the program that he was familiar with. I think we see in these memoranda the authorization for that.
A point I made when we learned about the suspension of habeas corpus for non-citizens. If you were an American citizen and you were somehow declared a non-citizen, and you said, but I'm a citizen, I have my birth certificate with me, my passport with me, you would have had no opportunity nor right to go to a judge to prove it. So effectively, a rule that was supposedly just pertaining to non-citizens applied to anybody, right? That's at the heart of this, isn't it?
That's exactly it, and that's the reason why I use the word dictatorship. That is, there's no division of power or authority. There's no role reserved for judges to hear your complaint. There's no role for Congress. It's all up to the executive. In fact, it's even worse than you portray it. I mean, the president, if he wants, can have you squirreled away in the brig in Charleston, South Carolina, and he can have you tortured there. And you have no appeal from that in these OLC opinions. Of course, that's not the law. It's a ridiculous portrayal of the law. But it's what the OLC told the president he could do.
So what do we have to do about this now? Obviously, these things were rolled back in those final cover-your-butt memos, but so presumably they're not in effect anymore. Yet you can't just say, well, oh, good, we got through that, everything's great. Do we have Pat Leahy's Truth Commission? Is there a special prosecutor? Do we need to all get pitchforks and torches and go to somebody's house? What do we do?
Well, maybe not the pitchforks and torches, but I think the other options you talk about are in order. In fact, I'd add one thing to the beginning, and that is bar disciplinary proceedings. I think that we know that there's an internal investigation inside the Justice Department looking at these memoranda. I'm told that it draws harsh conclusions and it recommends disciplinary actions. No surprise here about that. I think any lawyer would think that. But we also have got to get to the bottom of these programs. Why why were these memoranda crafted, who requested them, and how were they used, how were they relied upon. And Stephen Bradbury says in one memo, it's a sort of a throwaway line, that they were rarely relied upon. Well, of course, all you have to do is have someone rely upon them one time to authorize a program, and they could be used for 7 years and tens of thousands of times.
And do we have any indication, having looked at this carefully, does it look, you said crafted. This does not look like a paranoid response to a cataclysmic event that we all went through in September of 2001. In that sense, it doesn't look like somebody panicking. It looks crafted.
Absolutely. I mean, these memoranda are extensive. They have lengthy historical discussions. I'd say looking at them, they look an awful lot like law review articles and books that have been written by John Yoo. It looks like John Yoo's found an opportunity to turn his nutty legal theories into opinions of the Attorney General, and that's what he did.
Well, we'll keep one finger crossed here that it's his last opportunity to do that. Scott Horton, national security lawyer, contributing editor at Harper's Magazine. Thanks for stating this as bluntly as you have. Thanks for being here, too.
Great to be with you.